Admitted. So good evening, everybody. I'm Bhavesh Panjwani, the co-chair of the IMC Arbitration Committee. In a long series of webinars, this is a continuation of those series. So first off, I'll introduce the moderator, Mr. Vyom Shah, and then he'll take the proceedings further. Thank you for joining and welcome to the webinar.
Yes. Good evening, everybody. Thank you for joining us on a Friday evening, but it's going to be a very interesting discussion. And may I only introduce our speakers, our panelists first. May I introduce Mr. Gaurav Banerjee. He's a senior advocate appearing in the Supreme Court of India and also the president of the Arbitration Bar of India. He's appeared in varied cases before the Indian courts and in many domestic and international arbitrations in India and overseas. He's an alumnus of Cambridge University, from where he graduated with first-class honors and has been practicing in India since 1990. As an additional Solicitor General of India in the Supreme Court, he represented the Union of India in many sensitive and landmark cases. Mr. Banerjee has also been appointed amicus curiae by the courts, including the Supreme Court, in several matters relating to land laws, international commercial arbitration, Supreme Court practice and procedure, as well as indirect tax. He is also an overseas associate at the Essex Court Chambers, London. Mr. Banerjee has appeared as amicus curiae in the NN Global matters of great significance in the context of arbitration and stamp duty, and also in the 7-judge Constitution Bench judgment in the interplay between arbitration agreements under the Arbitration and Conciliation Act and the Stamp Act, which held inter alia that parties may be referred to arbitration despite an unstamped or insufficiently stamped agreement. Mr. Banerjee, we're grateful to have you here and to speak with us on the arbitration bar. Thank you so much.
Thank you.
May I introduce Mr. Shikhar Suri, who's also a member of the IMC Arbitration Committee. He's also a senior advocate practicing before the Honorable Supreme Court, the Delhi High Court, the NCLAT, the NCLT, and other fora. His practice focuses on commercial litigation, dispute resolution, criminal law, and public causes. Shikhar earned his law degree and an LLM from University of Mumbai and certificate in business and public policy from the University of Pennsylvania Law School in the Wharton School, US. He's practiced with the law firm of Messrs. Mullah and Mullah in Mumbai, and also at an AM Law 100 firm, Crowell and Mooring in Washington, D.C. in the field of litigation and dispute resolution. He's a member of the IMC Arbitration Committee, as I said, and the former co-chair of the India Committee of the Arbitration Bar Association, section of International Law, and the former chapter chair for India of the New York State Bar Association International Section, and is actively involved in promoting ties and building bridges between Indian and legal communities worldwide. Then we have Mr. Gautam Mehta, who is our third panelist. He's an advocate, a counsel, and an arbitrator. His areas of practice are as counsel in civil and commercial litigations and in arbitrations, both as counsel and as well frequently appointed as arbitrator. He has conducted several arbitrations as arbitrator, either appointed by the parties or by court. His primary areas of practice are arbitrations, final hearings, and trials. He has appeared as counsel before courts, including the Bombay High Court, the Supreme Court, City Civil Court, PRT, DRAT, tribunals, commissions, etc. He regularly delivers lectures and talks on arbitration law and practice at various institutions and bodies. He briefly assisted late Mr. D.N. Popat, who was senior partner Mullah & Mullah, Craigie Blunt and Caro, while Mr. Popat was working as part of the consultation committee for drafting of the 1996 Arbitration Act. He's been involved in the IMC Chamber of Commerce and Industry for almost 2 decades as a member, co-chairman, and chairman of its arbitration committee. He's one of the key persons in devising and conduct of IMC's flagship event, which is the 7-day arbitration course that is held annually for the last 17 years now, and its other activities include webinars and seminars such as this one that we have today. He's also a speaker at the IMC 7-day arbitration course. He, for the past several years, is also a member of the IMC Managing Committee, and currently he's also IMC's representative member to the Indian Council of Arbitration. He's also represented IMC before parliamentary committees on arbitration and mediation. So we have a very interesting session, as I was saying, and if I may only say so, this is not really about that much about the law of arbitration, but the practice of arbitration and how that affects us arbitration practitioners in so many ways. So may I first go straight into the conversation and ask a question to Mr. Banerjee? So there have been discussions on having an arbitration bar for a very long time now. According to you, what is the necessity for an arbitration bar like this? And what really was the history behind this movement? This could not have been an easy thing to do.
We have been talking about this for a long time. If you would have seen the Sri Krishna committee's report of 2019, which brought out some amendments to arbitration. It also mentions dedicated arbitration bar. So the idea has been there for quite a long time. But the reality is that at least when we started, arbitration was pretty much something you did in the evening after court at weekends. I remember in Calcutta, you used to have a cup of tea, then you had an arbitration, and then half an hour later, there would be some food to have, and then by 1.5 hours, it would be over. But I think, the world has changed. Winds of liberalization, and particularly in the last 5 or 10 years, a lot of youngsters keep meeting me and others, and they want to make this a full-time career. And the reality is that, it is the growth of the bar has been very fragmented. So the idea was essentially to have a dedicated bar of individuals who will come together and in the hope that more heads are better than one, and we will have a strong bar which will improve professionalism. There are many other things that will be achieved, but you asked what is the history. The history is that actually just after the Attorney General took over, literally 2 days after that, there was a SIAC conference, and there was this free flowing discussion, and everybody was talking about this SIAC and this LCI. And then the thought was, what are we doing? We have so many good institutions. IMC is there, other institutions are there, but there's no bar. So he proposed the idea. Then some people got together. Then we reached out to some people in the government. We reached out to arbitration practitioners, and that's how it came.
And in fact, this really strikes home because as youngsters trying to spend our practice, or rather devoting our practice to arbitration, we always wonder how exactly to go about it, especially with the court also taking it sometimes. This makes sense. My next question is to Shikhil. Now, Shikhil, the concept of arbitration is obviously not restricted to India, but is an arbitration bar also a global concept? In that sense, are there domestic arbitration bars in other countries, or is there an arbitration bar for practitioners of international arbitration? What was their role, if there is?
Well, thanks, Joe. Let me first take this opportunity, and I'd like to actually begin by complimenting everybody who's involved with the arbitration bar of India in setting this up, particularly Mr. Banerjee, and of course, the support of the learned Attorney General and the learned Solicitor General. So first things first, acknowledgement and compliments to Mr. Banerjee and his team. Because like Mr. Banerjee said, we've all been, discussing about this bar. I remember Mr. Popert, who you mentioned and who's been a mentor to a large number of people who are on this call, always used to tell us when we started our practice, about the need of having a dedicated bar. And this was many years ago, and I'm not going to give you the number so that we don't sound dated, but this was many, many years ago. And now this is in fact really, a vision or a dream come true, and particularly during, our practice tenure. So very happy to see that. And also the other very unique aspect about this bar is that, look, there is no such dedicated arbitration bar across India. I can, speak about the US where I've lived and practiced. And there, you have organizations like the American Bar Association or the International Bar Association, which, all of us are aware of. And they have a dedicated section of international arbitration or a section which deals with arbitration. but you don't have a particular dedicated arbitration bar, with the stature and the status that has come to be now associated with this bar. So very unique in that sense, and very happy to see India sort of leading this effort. And the other aspect which I wanted to point out was the American Bar Association, or the IBA, is very restricted in that sense that it has only as its members practicing lawyers, or maybe some academicians. But from what little I understand of this bar, it is an open arms policy, starting from anybody who's an arbitration enthusiast to a practitioner, and that I think is a very wide sort of reach. And like Mr. Banerjee said, the more heads that come together, the better the output. So I think all in all, it all serves very well for the cause of arbitration.
So can I comment on that? Thank you for that endorsement, Shakil. But what is interesting is we had a lot of discussions on this, whether we should restrict it only to lawyers. What is the way to bring more people in? After all, it's not just lawyers. There are so many individuals who are involved. There are, engineers, chartered accountants. Then there are experts who give evidence. So the idea was to have a larger pool. Obviously, there was some internal discussions about what is the nature of membership, but and the other model we thought was, you have a tax bar, you have a all India, pan India subject specialist bars, maybe something like that. So that's how we came up with this idea. So I'm glad at least there's one vote of confidence here.
Mr. Banerjee, you have 2 votes of confidence.
Thank you.
Mine also.
I was about to say there are many more, but yes. That's so now my next question is for Mr. Mehta. So when I studied the Arbitration Act in school, it was a relatively easy subject to study. But then you realize that practice is different. There is a lot more to understand, even the practice of arbitration. So that's why I guess it is also very important for young arbitrators to have some sort of a mentorship, hands-on training. Like Mr. Banerjee said, you have so many young people now looking to get into the arbitration practice and dedicate their career to that. So what, according to you, should be the role of the arbitration bar for the future generations of arbitration practitioners, either as lawyers or as arbitrators?
Thank you, Vyom. Nice, very nice, interesting question. First, let me begin by thanking Mr. Banerjee for so willingly agreeing to join us and to do this, After all, now, as we say, always there's a leader of the bar. So today he's the leader of the arbitration bar as its president. And having him over to do this is an honor for us, and I hope it helps others. The second point I wish to make, that what Mr. Banerjee said about Calcutta applies to Mumbai also. I remember when I joined the profession, I was with my senior, and suddenly one afternoon he said, "Come on, let's go, we're going for arbitration." So I was putting on my coat, tie and everything, and then he said, all this is not required. So I was a little perplexed. And he was grinning away, and people around him were grinning away. Then one of them said, "Listen, arbitration is a code word for going out for lunch to a restaurant." So that was my introduction to arbitration. But of course, things have moved. And the third point I wanted to make is, yes, ever since I remember, Mr. Popat has been saying, we require a dedicated arbitration bar. Had he been there today, he would have been one of those happy people in supporting this wholeheartedly. And especially you, Mr. Banerjee, and the Attorney General and the Solicitor General for this. You would be thanking you all for making that dream come true. Thank you so much. Now, to answer the question, Vyom, as I see, this question has 4 parts. What you mentioned was a practice aspect versus a theory aspect. Then there is the part about training, mentoring, what I generally call is chambering. And fourth, what role can the arbitration bar play? Now, bear in mind that basically there are at least four stakeholders in an arbitration. There are the parties, there are lawyers, there are arbitrators, there are participants, and possibly institution involved. So yes, the practice and theory aspect are very crucial. But if you have theory, it is like you know how to play a video game, learn how to drive a car, a fighter plane, everything. But then when you get on the ground or get in the air, it's something totally different. So that is true even of the practice of law and even of arbitrations. So it is very important that not only there is good knowledge of theory, that is your basic foundation, but it is even more important to have knowledge of practice and gain experience and skills in practice, because that is where you'll really learn to apply all your knowledge. If you don't have knowledge, you can't apply, and even if you have knowledge and but you don't have the practice, the skill set or training to practice, that knowledge is not great. So like science, you have a lot of theories and a lot of ideas, but when they are put into practical application, that's when it really works. The same is with law, same is with arbitration. So arm yourselves with knowledge and apply. So mentorship and training important. Now I have a little slight dilemma on this in arbitration law. Considering section 42 of the ACA, the point is, how do you involve somebody as a junior, or whether with an arbitrator or with a counsel or somebody who's not a party to that arbitral proceedings? Because the act, the provision of 42A is very strong on confidentiality of the arbitral proceedings. So this is something that requires to be overcome. It's not unsurmountable, but can be overcome. So to bring those juniors in and everybody in to learn the practice part, I think we could evolve a mechanism where we take consent of parties, inform them, and take a declaration from the trainees, that they will maintain the confidentiality in arbitration proceedings and the award part of it. So again, this may only apply to arbitrators, and I don't think it would apply to advocates as such. Because if you go to see, advocates have on their team junior lawyers, trainees, everybody, and they attend arbitration. So I don't think that would be a problem for that. I would suggest that since the arbitration bar of India has started, we can develop and draw up some protocols, guidelines for our members and others to adopt and use. And finally, where practice is concerned, I always feel, and this was endorsed by Justice Sharad Bobde when he was the Chief Justice of India, he said this do-it-yourself model that is now happening across the bar is not good. You require training, you require mentoring, you require chambering, and it is important that this is promoted and assisted by some specialized bar like our arbitration. I'm already saying our arbitration bar of India.
Thank you. Those were some very interesting insights and I'm sure quite helpful. Now, Mr. Banerjee, sir, the constitution of the Arbitration Bar of India also includes the Learned Attorney General and the Solicitor Generals of India. So clearly, this is not just a private party of individuals that have come together to start something, which is also quite significant. So in that context, sir, what do you see of the role of ABI and maybe influencing the laws that relate to arbitration, the practices of arbitration?
So,
is that something that bar is looking at doing? Sorry.
I mean, you are right. The AG is there as the patron in chief. The SG is there as the honorary president. But it's not a government organization like an IIAC where you have a statute and a government. That was never the idea. And I think both the AG and the SG were relatively clear about that. It's basically, certainly we have the backing of the government or the blessings of the government, but I think in that sense, we are autonomous And I think the easiest demonstration there was that we did take on the government on the circular. So I don't think we are a government organization in that sense. Yes, we are obviously working closely with the government. When the inauguration took place, we were fortunate that the foreign minister and Mr. Vaishnav was also there. But really, to answer your question, you know what I've been doing. I think I will let you into a secret. While Mr. Mehta was speaking, I was taking notes, because what is this? This is a process of discovery, and the one, you know, he said it's a great honor to have so and so here. But the reality is, we are also trying to learn as to what people want from the arbitration bar. So there was a function in Bombay, which Mr. Mehta was there, and Mr. Ketan Parekh made a number of suggestions, and I noted all of them down. So that is what I was doing. So it's an evolving process. So to answer your question, actually, there are many things that can be done, and we are still in the process of formulating what can be done. But I think what is most important is that the prime focus has to be the members, and the whether full members, associate members, other members. After all, you're a bar. Why should one cough up good money to join you until and unless you actually offer them something? And there are many things that one can offer, and something as basic as a directory where people know who are the arbitration practitioners. But I think one focus which at least is very close to my heart, and what Mr. Mehta said, is this capacity building, knowledge sharing, training, the training aspect, the younger lot, you know, how to involve them, how to have some degree of professionalism, whether it is, you know, setting standards or guidelines or workshops, or as now has been suggested by Mr. Mehta. I think it's a great suggestion, which is mentoring certain youngsters, maybe bringing them in to on-the-job training, maybe institutionalizing this a little more. After all, how did we learn? We went and saw, you know, the great and the good doing the cross-examination. We learned because of that, not because of reading the Arbitration Act and the book. How to do matters, how not to do matters. That also one has seen. So I think, you know, there are any number of things that are there that one can focus on. And I think one of the problems I am facing as the president, and we are facing as a committee, is that we are being bombarded with so many ideas that it is difficult to focus on what is there. Some people are saying your job is to you know, promote diversity. Some people are saying your job is to lobby the government. Some people are saying your job is training. So we are still grappling with exactly where we are going. But the reality is, we are still, you know, gathering that information to go ahead and then implement it. So we've done an event in Bombay. We are thinking of doing events in other towns, trying to understand the appetite, you know, and also one other point, which was a major point which was made, is arbitration practitioners should not just be talking to arbitration practitioners. You know, the most important people, as Mr. Mehta said, there are four categories of people, but here the most important people are the parties. So we are trying to interact with, you know, parties, you know, commercial organizations, or with government. The AG and SG have promised to set us up with government to understand what do they want from lawyers and from the bar, and you know, even arbitrators, younger arbitrators. It's a very wide canvas. So we're struggling with a I love the word vision, but I mean, we're struggling with the vision.
Right. No, so it does sound like, and it would be an evolving process, but I can say from the context of generally a younger lawyer, we don't see trials in court very often. So it's really, we look to arbitrations, and in that context, it would be very helpful to have the arbitration bar also imparting that sort of knowledge to younger practitioners. Definitely.
I think arbitration bar imparting this thing. I think the role of the arbitration bar will be to connect younger practitioners to more experienced practitioners who will be willing to do this, somehow
Right.
streamlining the
Maybe take it on.
process. Yeah.
Can I just suggest something
I
on
guess
this? Mr. Banerjee, I don't know whether you're aware that Bombay Bar Association tied up with International Advocacy Training. There's a council or something based in Malaysia at present and Hong Kong. So they're all over the world. So BBA tied up with them, and they started an advocacy training course for young lawyers in Mumbai. I happened to be a part of it because I was pushed into being one of the first first group to take training and get certification. So far we have done about 4 or 5, and it's on the basic of advocacy. It works beautifully. It has worked so well that people who have participated in it to learn the art of advocacy, in the sense that examination, cross-examination, final arguments, that is what we do over 2.5 days case analysis. It worked beautifully, and a lot of people, of course, there was an incident which happened, that one of the trainers who trained a junior, and that junior was in court and was trying to implement this technique, and the judge blasted him to the edge of the galaxy. So the trainer felt very embarrassed and said, "Have we done something wrong?" So we said, "No, these things happen. We have to live and learn." But on the other hand, great feedback from this. It was a suggestion.
So, right. I'm noting all this. It will come back to bite you, Mr. Mehta.
I will support in every way. I will
Yeah.
support in every way, and so will IMC and my entire arbitration committee.
That is very good to hear.
So now may we come to the circular that you had mentioned. It was, and for the benefit of our listeners, if they aren't aware of the circular, there was a recent circular that was applicable to government entities, PSUs, public sector banks. This was, I think, in around June 2024, which said arbitration as a method of alternate dispute resolution. This is the language, should not be routinely included in procurement contracts, tenders, especially large contracts. And if included, may be restricted to disputes with a value of less than rupees 10 crores. I would think that renders arbitration as a dispute resolution mechanism largely absent in the context of government entities and PSUs. And of course, there's a lot of work over there. What are your thoughts on the circular? And we know that the ABI has done something. You all addressed a fairly detailed representation, sir. So now, what do you see as the way forward? Is there any idea?
So I think actually, to be frank, this caught everybody by surprise. This happened in the first week, or I think first week of June. I'm not sure exactly the date. The courts, at least in Delhi, were shut. A large number of lawyers and judges were in the UK. It was the India arbitration. It was the London arbitration week there. Everybody was saying, we are open for business. India is an arbitration hub. And then this circular came. So it was a bit of a shock. I think, and then there was obviously a lot of pushback. We made this representation. And then what has happened is somebody's challenged this circular in the Delhi High Court. But I really feel that I don't think there is a legal challenge here. We haven't seen the petition. The petition has been filed, notice has been issued. Arbitration Bar of India is, I think, being made a party or whatever it is. It'll come up in December. So I don't think there's a legal solution to this, because after all, it's the policy of the government whether to have arbitration or not. The way to tackle this is very different, and the way to tackle this is, people like IMC, people like us, industry particularly is very, very disturbed by this. And this appears to have emanated from effectively the finance ministry. And in some ways, the law ministry has been blindsided. They were really not aware, or so they say. Nobody is taking ownership of this circular. Now, the way government works, I have also been in government, is that once something is done, then to undo it is very problematic. Somebody asked a question in parliament, so they had to defend the circular. And moment you attack a circular, then the first thing is defense. So maybe some sort of modification, some sort of revision, um, some sort of deviation. But I think what we need to realize, and I'm now speaking not as an arbitration lawyer, but as a interested bystander, is that there is a sense in the government circles that arbitration is suffering a crisis of confidence amongst users, and not only government, many people who are large contractors. And I think the problem here is they are not confident of the arbitrators, and they are not confident of the arbitral awards. And in the recent past, the PSUs have suffered huge awards, and some of them perhaps may not be justified. So one has to work with these people to find a via media. There's no point saying this is very bad without actually finding a solution to this. And one solution is institutionalization, more professional lawyers, but most importantly, everything depends on the arbitrator quality. And forget about the government. I want, you are all very senior lawyers. You all have clients. You ask your clients, are you happy with this system? Are you happy with trusting your case here? So there is a problem. On the other hand, the larger contractors are very upset at the moment because they are saying that there's no relief now. Now I go for a tender, there is no arbitration clause. So what am I supposed to do? I'm supposed to file a civil suit, which never commercial suit. I don't know how it happens in Bombay. I mean, in Delhi, there's a problem. Bombay, any other commercial city, I mean, it's gone. Then you try and find extrajudicial ways of trying to settle the matter. This is what we are trying to explain to the government, that you have not solved the problem. You can't simply bury your head in the sand and say no arbitration, therefore. And this is apart from the fact that you are saying to the world at large, India is the arbitration hub, we are amending our act, etc., etc. So it's a work in progress. I'm not sure where it will go to, but I think if one can drum up sufficient public opinion, that is the only way of doing it. So ABI is only one cog in the wheel. Whether it is IMC, whether it is anybody else, we have reached out to chambers of commerce to also represent. Let's see what happens.
Can I just add something to this? What Mr. Banerjee said about, and this is truly the point, that amongst the stakeholders about parties, they're the ones who are really upset about the whole thing because they feel that they are getting a short stick. They're drawing the shorter stick amongst everybody, and actually, I really feel it's the claimant who's really suffering, not the respondent. The respondent sits pretty sweet, happy for a long time in the hope that he can drum up any kind of defense, and that because of the quality of the arbitrators, you never know. It's a gamble, Las Vegas style. You take your chance, anything can happen. But yes, the claimants are genuinely worried, concerned, and this thing. But I wanted to ask on this a question to Mr. Banerjee, that is it because of the ad hoc nature of arbitrations, or is it because there is no institutionalization, there is a lack of trust or worry? That is what, this is my sudden question.
So I would say that it is a lack of credible institutions, uh, and therefore credible arbitrators. If you have an institution which is exercising some degree of supervision on who your arbitrator is, So you cannot guarantee the honesty of an arbitrator, right? But as an institution, you have some degree of control. For instance, I mean, DIAC has introduced this. I don't know whether IMC may or may not be thinking about it. They have introduced now scrutiny of awards, um, just to see whether the reasoning is there, whether all the issues are there. And I was scrutinizing an award of a very senior arbitrator, and I was shocked. I was shocked in the sense that the reasoning was very, very sketchy. There was no dispositive portion. There was nothing on costs. There was nothing on interest. So if you have a credible institution, you will get out a better product, namely a better award. Also, you will have control over who you appoint as arbitrator, so that there is some check. For instance, you will take on somebody who says, and you will insist on that person or persons being available on certain dates. Otherwise, in ad hoc arbitration, the arbitrator says, sorry, I'm busy for 6 months. This happens to us all the time in large high stake matters. So I would agree with you that that is the solution, but that may not be entirely the solution, but that is certainly 70, 80 or 90% of the solution. But then we'll have to come up with, institutions like IMC and otherwise, and convince people of their credibility.
Thank you. Yeah, Vyom, over to you.
Yes. My next question, Shikhil. To you, arbitration in our country is obviously diverse, and as Mr. Banerjee mentioned earlier, we have domain experts, we have engineers, chartered accountants, insurance matters, actuaries, etc. They either appear as counsel in arbitrations, they're also appointed as arbitrators. So, in the context of the arbitration bar of India, what do you consider the necessities for ensuring this sort of inclusivity of persons from diverse backgrounds?
Well, I think, like Mr. Banerjee mentioned, he has a number of suggestions coming from different quarters, and I think my own take on that, it's a good problem to have. The fact that he's being bombarded with suggestions and ideas, and that he's making notes, it's a good problem, because it shows that there is interest, there is the importance to the whole issue, and that people are concerned. So therefore, I feel the formation of this bar in that sense is also very timely. We are at a stage where I think the end user of this whole process is looking for some answers, looking for some real tangible solutions. We are at that edge, I think. So for the bar to get together and address this, I think it is very critical. So just to add to Mr. Banerjee's problem, I think it's a very critical role which the bar will need to play in ensuring that all the issues that we are all grappling with are addressed, and at a fast pace. We run the risk of losing what has been built over all these years. So that's one. Now, just coming back to your question about specifics, diversity, yes, I think it's a no-brainer. It's a no-brainer. I think diversity in this whole pool is a no-brainer. It has to be academicians. It has to be people who are involved, engineers, lawyers, young practitioners, and the end users as well. I would encourage the bar to have the end users, and I think the facilitator or the person would be like the GC of let's say the end user would be the point of contact between the business and the bar. So encouraging the end user to participate, that's one. And second, deepening sort of the reach of the bar. And I think that might take some time, because we have to take baby steps as we grow. But deepening the reach of the bar, what I mean by that is not just the tier 1 cities, not just Bombay, Delhi, or Bangalore or Calcutta. We need to look at the tier 2 cities, the tier 3 cities, because that's really where you are having all these disputes emanating, not just the bigger cities. I mean, the bigger cities have the lawyers, but the end users and the real issues are arising in the tier 2, tier 3 cities as well. So deepening that as well.
So in fact, in the tier 2 and tier 3 cities, just to respond to what Shakil is saying, there's a huge problem. I mean, they have not, we were talking, I mean, we are not talking tier 2 and tier 3. I mean, Lucknow is not a tier 2 city. Lucknow is a state capital. The understanding of, or you go to a district court there, the understanding of the Arbitration Act is virtually zero. There are only 20 or 30 individuals who are actually familiar with this. And there the target is very different. That target is not, the degree of training there is required is minimal. There is no idea. The other problem is that many of these arbitration disputes, I think your Chief Justice of Bombay High Court mentioned the example of that finance company arbitration of a farmer in UP. A lot of commercial disputes are of very low value. I don't know what IMC does, but I know, for instance, other chambers don't want to do this. So it is not sexy to do this. So there are a huge number of very small MSME and other disputes which are also going to arbitration. How does one tackle that? That's another, black hole.
Can I just add to this? Can I just add to this?
Please go ahead.
Since you mentioned IMC, you see, IMC, if you go to see, has only about 2,000 members technically. But amongst those 2,000, we have what we call FA members, that Federation of Associations. And each association has between 50 to 60,000 members. So on last count, when we counted, the total membership, indirect membership of IMC was almost about 3 or 4 lakhs. And it consists of these various associations. And in fact, we are trying to reach out to them that how we can assist them in arbitration, in arbitrating their disputes. And I'll share the feedback that we get from them with you.
And particularly, it's a low value dispute because it's
low value, very low value.
MSME, etc. I see some of the awards that come out of these MSMEs, they are shockingly bad. And it's a problem. So maybe some training there, training for MSMEs, maybe some lawyers who do this regularly, maybe some involvement from their side. I don't know. That is another target of the bar, because after all, we are not looking only for fancy Singapore and London. I mean, this is we have to get our house in order in India rather than look abroad at the first instance.
May I just add to that we have 17 years of experience in conducting arbitration courses every year. And we also want to increase it because the spread of it, so we have started going hybrid. In the sense, like if you go to see who's on a panel of trainers, people who conduct, sitting high court judges who are doing arbitrations or have done arbitration, senior advocates who have done arbitrations, who are in arbitration practice, they are the ones who are training. So we have a limited intake physical, but pretty large intake on the hybrid online. So yes, we've realized one thing, that this kind of training, we are only doing theory.
Right.
And taking people through the entire Arbitration Act. But that is a starting point, a springboard for people to understand. And in fact, with our training, we are giving them material. Every lecture, a material is delivered. And if you go to see, I have been told by sitting high court judges, like turning around and saying, your material is lying here. It is so helpful because it has the latest case laws and it has discussion on various topics. It's very detailed. So, this kind of thing also, if ABI takes up and we could assist, will work wonders.
I think this is a great idea because we have a ready package here which can be transported out of Bombay to various other. You can export this to other parts of the country at least.
Yes, most certainly. We would be so happy to do it, Go ahead. Sorry.
No, that's quite promising. And in fact, if I may also add, And the IMC Arbitration Center also has summary claims arbitration procedure rules. So for smaller claims, that may be of some assistance. But anyway, that's only one more aspect to add.
Yes.
The next question is to Mr. Mehta. What do you consider the benefits that should be attached to maybe obtaining membership of the Arbitration Bar of
A
India?
very important question, because I have to answer to this question. I mean, I'm noting the answer here so that I can repeat it.
Please tell me at the end of it how convincing I am. So, let me start by a simple thing that if historically you look at it, whether you're a lawyer, you're a fitter, a plumber, whatever skill set you have, in olden days there used to be guilds. One had to join a guild to get trained. And then in that guild, you rose from trainee to master craftsman. So if you go to see, even under the Advocates Act, what is it? From advocate to senior advocate. So master craftsman, it's a guild. So if you look at in modern times, what are we seeing? We are seeing various associations, whether chartered accountants, architects, cost accountants, everything, whether through legislation or merely by association and collection of people, these associations are there. And if you think that by staying out of it, it's going to benefit you, I think no, you're wrong. And as far as arbitration goes, it's a super specialty now. So when you look at doctors also, you find that there are doctors who specialize in the end toe of the left foot, just one. So it's a kind of a specialization, and so is arbitration. So if you are considering that you want to do arbitration and take it as a full-time career, and please, as a full-time career, I'm serious about that, because this part-time, evening show business is really horrible. So then you should be a member of the bar. It is a necessity. And let me tell you very frankly, as I mentioned in the beginning, this is an idea whose time has come and was long overdue. Now, when we talk of benefits, my point is simple. How it will benefit a person doesn't depend only on the member. It will depend very strongly on the organization, the way it conducts itself for the benefit of all its members, and has a larger vision. I'm using the word vision for the practice of arbitration. And sorry to put a sour note, hope it does not become a closed club or an exclusive or select domain of a few. That will make it lose its credibility, trust, and belief. If it does, gradually over time, people will lose their faith, and then it will become just another association. Let us not have that happen. If we gain the trust of members that we are there for all of them, everybody who practices arbitration, whether we do something, don't do something, but we are there to listen. We are there to promote arbitration, and we are doing it using the words of Section 12 of the Arbitration Act in an independent and impartial manner. Then people will trust us. If we provide learning, they will trust us. If we update them, it will trust us. And always it is better to be a part of a specific, important, specialized association than any generic association. So supposing you are an advocate, you are going to continue to remain as a part of the bar. But then if you become a member of the Arbitration Bar of India, you are part of a very specialized bar also that is dedicated to a particular aspect. So it is very important for people to take this initiative with both hands. Of course, fees is a different matter, so that I will leave to the goodness of the heart of the president and the entire ABI committee. Because if you go to see young people, I don't think everybody has. If you talk of tier 2, tier 3, tier 4 cities, it's a problem. So something has to be done.
I think we are looking at that. I think probably that is meant for tier 1 and super tier 1 cities. I think don't think in many tier 2, tier 3 cities you will get any response with that sort of fee. I follow that.
In humor, let me add one thing. That those who are designated seniors and want to join the bar, double the fee. They can afford it. They've made enough out of everything.
Right. We can. Mr. Suri, you please note this point.
Sir, I'll follow your lead.
I think that may be another way of doing it. Huh?
It is called cross-subsidizing.
Patron member, some life member, some other member to raise money, or some senior member or something like that.
And don't create too many classifications. This is my advice.
Or keep it as member, but people who are senior advocates should pay more for the privilege.
That's right.
That may be.
But I think ultimately the point is accessibility. We have to make it accessible. I mean, if not now, but over a period of time, it has to be.
I think the most important point that Mr. Mehta made is hope it does not become a closed club.
Yeah.
There is the point. But sir, then the question is, what do we do in order to increase the reach? One is fees, maybe training. Any other idea?
Sir,
some sort of directory, some sort of, I'm trying to figure out. You said guild. Why should somebody become a member of your guild? That's a question which has been bothering me.
Correct. Sir, one of the things is that maybe we can tie up, and I'm using the word we, though I'm not a member yet, but I'm using the word we.
You are a putative member, already a member.
Thank you, sir. So I am saying that one of the things we can do is tie up with somebody and start coming out with our own journal and get people to contribute to that journal. It makes them involved. Younger members, senior members, writing in a journal, contributing will increase their sense of belonging and involvement. Having conferences, serious conferences on law, where everybody, you have the three members with experience and all as speakers, but take some younger people who are not so well known, identify them, and give them an opportunity to present. It increases the sense of belonging. Everybody feels that may get a chance if I can prove myself. But when you go to some of the seminars, you see the names at the back. So the common term, sorry, they are all my friends, but I will use that term nonetheless. Usual suspects are all there, So let it not be only of usual suspects. So conferences, journals, opportunity to speak.
Sorry.
Sir, I would just add one more suggestion. I mean, I think you're well aware of these opportunities that one would, the young generation would benefit is by speaking, writing, participating. But real actual participation, just to sort of go back in sort of my career, we were fortunate to have worked with Mr. Popert and exposed to international arbitration by virtue of working in his chamber. He was India's representative to ICC court, and so by virtue of being part of his chamber, we were exposed to that. But now the younger generation, if they are not associated with a chamber, or maybe a senior advocate or a firm which does arbitration, are looking for opportunities. So a mentor-mentee program where youngsters, younger generation would get a chance to participate in a real, actual live arbitration. So things like that, like a mentor-mentee program, actual participation is something which would be very attractive. I'm sure a lot of people on the call would be wanting to participate in arbitrations, but don't really get the opportunity because one gets the sense that there's only a select group of people who are doing this. So opening
what is very interesting, Shakil, is I'm hearing this consistently here also and earlier also, that there is a closed club, that there is a select group, that only a select few are doing this. That's not a good sign, because at least from what I've seen internationally also, uh, Indian lawyers are supremely talented. So there's no lack of talent here. It's just the opportunity which is
That's right.
missing. So you're right. But this phrase closed club or select few um, organization should not happen. That's always difficult, because they, the knee jerk reaction is to interact with familiar people.
That's right.
You have to understand that. So, when you set up something, obviously you interact with the usual suspects. To get out of that will require some effort. I follow.
I think it's on the usual suspects to
It's an effort which will have to be made in
yes,
the interests of
for all the
larger.
usual
Yes.
Can I add some?
Yeah, go ahead.
Yeah, can I just add something about the usual suspecting? See, the IMC Arbitration Committee, I have been a part of it from 2007, member, then co-chairman, then chairman, and worked with Mr. Popat till he was alive. He was the chairperson. So I got to learn a lot. And his idea was inclusiveness. So he was very keen that people who are practicing or interested in arbitration will be a part of this committee, irrespective of their stature and status. So the youngest to somebody very senior, and he was not too very enamored with superstars. So he said that they are already made; they don't require any platform. But we must give opportunity to people who otherwise will not get an opportunity. So then I'm reminded of Section 18 of the Arbitration Act, which says, treat equally and give full opportunity. So that becomes relevant. That it must not only happen, but must also be seen to happen for people to be a part of an organization. And
if I may just add,
sorry,
things are virtual now. It's easier to connect people, and I think members, especially young members, would be very happy if ABI can connect. Someone maybe in Karnataka with someone in Delhi, and even virtually, younger members can learn so much. So just to provide a platform to connect would also be quite helpful.
I'll just add one more thing. Interestingly, I was listening to an interview on YouTube, The Record, by Mohandas Pai of Nandan Nilekani. And what amazed me was, I sat upright when that question was asked of Nandan Nilekani, that don't you feel insecure that when you're bringing in so many people who are talented and supremely talented? He said, nothing. I don't feel insecure at all. And the reason for that is that it's not about me. It is about the purpose that we have set out to achieve, the goal. So if somebody does it better than me, why not? So I should not feel insecure. And I thought that was a very important thing that all of us, at least even I certainly would want to imbibe. That why should I feel insecure? Give opportunity to everybody. Whoever shines ultimately shines for the benefit of the bar, for arbitration or promoting arbitration. That is what matters.
Right. So then now to Mr. Banerjee, sir, in the context of memberships, there are different kinds of memberships. So what are these different kinds of memberships? We won't get into the fees aspect because you said that is something you're reconsidering. But generally, what are
It's all on the website. Basically, there are three categories. One is essentially a full member, and associate member, and then honorary member. And the reason we've kept full member a little different from associate member is that you may not want to, sort of commit yourself fully, uh, even though you may have the requisite experience, you may still want to be an associate member to see what is happening. For full membership, we thought it should be better to have, some degree of experience in arbitration, maybe 10 years or such. And for associate member, we've kept it very wide. so that that choice is open to GCs also. It's open to non-advocates also. There's a lot of debate internally whether we should have full membership for GCs. At the moment, we have not done it because, after all, we are a bar. So whether no doubt you're a GC, but ultimately you're not an advocate in the sense that you're not really part of the bar yet. I know GCs are trying to get rights of audience and such. So that was a debate. So overseas, so member, associate member, we've also got an honorary membership, which includes overseas practitioners, and maybe honorary membership to some of the great and the good, who we would like to drag in and become honorary membership, or give honorary membership. So basically, we put it up on the website. There are some slight hitches on the website, but I think if you just have a look at arbitrationbarofindia.com, you'll get a good idea as to what the story is for membership.
Thanks. Now, my next question, Shikhil. There's a lot of talk about party autonomy at the Section 11 stage. Party must have a choice with an appointment of an arbitrator. It should be, but according to me, party autonomy should be prevalent at the very beginning. Parties should be able to have an informed decision as to the costs of the arbitration and how do we make it more cost effective and efficient. That's how they probably can make a more informed decision about whether they want to go in for arbitration. So, what do you think can be done to streamline costs, promote efficiency, in the context of even the Arbitration Bar of India? And how they can really
yeah, like we discussed, Dome, I think this is a very, very important question. I think something that goes to the heart of the issues I think that we are facing. So party autonomy, like we discussed, doesn't really arise at the stage of an 11 or a 9. I think, according to me personally, it really arises the day you decide to enter into a transaction. Moment two parties decide that they want to enter into a transaction is when I think the party autonomy process should begin. And like we were discussing in our call, it's referred to as the midnight clause, and gets sort of shelved to be discussed at the end, or to be aped from a previous contract or from a previous experience of someone, and not really discussed and debated as much as we would want to. Of course, sophisticated parties, it's a different game. But the real users who we are talking about, maybe the small users, the MSMEs, people who are entering into contracts for the first time, or looking to having an arbitration clause, very, very critical for them to discuss, debate the arbitration agreement. I mean, and the threshold question, which I think they should decide, is whether they really want an arbitration agreement or not. And a lot of these issues arise from arbitration clauses which are thrust upon parties, where unknowingly these clauses find places in your contracts, these wraparound contracts, these click contracts. So very important for parties to, at that stage, determine whether they would want an arbitration, whether they would want any other procedures for alternative dispute resolution. So to be very clear on that, once they are clear on that, then of course, the usual, the seat, the governing law, and all the other ancillary issues that we are day in and day out seeing being litigated in courts. So if there's more clarity at the outset, then I would think that half these issues would be resolved. And the way to do that is, again, adding to Mr. Banerjee's work and Mr. Mehta's and all of our work, is again outreach, education, educating the end user about really, the need for an arbitration, the benefits, the cost benefit analysis, and everything involved with that process. So again, going back to the drawing board, going back to the basics and educating the end user, that to my mind would solve a lot of these issues that we see end up getting litigated. So yeah.
Right.
Can I add one more? Can I add one thing? Preeti, my wife, when I recently, about a year back, put a set of cartoons in my office, and one of those was of two old men with long beards before a judge. And the caption read, "We are litigating the arbitration clause which was meant to resolve the dispute faster." So it is important. What Shikhil said is spot on.
Yes, and in fact, there are some matters where you would want an arbitration, but maybe some matters, if arbitration is becoming expensive, then maybe that's not really the way forward. So I think that is something that parties should know in knowledge dissemination in that sense. Definitely. And thank you. My next question is to Mr. Mehta. So you're the chairman of the IMC Arbitration Committee for many years now. The IMC International ADR Center is also an established arbitral institution in Mumbai. How do you think arbitral institutions can work with ABI to promote ABI's objectives? That is, promoting the practice of arbitration in India, and we've all been talking about disseminating knowledge.
Vyom, it's a very good question. And when I heard about ABI, I was thinking and talking to some of my members how we can, and to the IMC secretariat, that how do we interact, how do we take this forward? I personally think that it cuts both ways. Most important is between ABI and institutions. Create a win-win situation which is mutually beneficial to both. None should feel that I am being used or I am being abused or I am just a stepney. It is important that both work together to promote arbitration. That is important. Let me put it like this, that today ABI, every institution of arbitration has its limitation on spread and reach. ABI, by being the arbitration bar of India, will very shortly have a very wide reach pan India. I would look at it in 2-3 years, it has to happen. And there are regional institutions everywhere. So if ABI plays big brother and reaches out to these institutions to support them, to encourage them, at the same time to get support and encourage support from them, and that trust is gained, they will support ABI. And their members will support ABI. Remember that members of these institutions, I'm talking of trade, commerce, business, all these institutions or arbitral institutions who are members or whatever, they all are sitting at the sideline wondering what will happen. Reach out to them, explain the benefits, take their support, give them support, create the trust. And that will work. So it's about trust ultimately, and the trust requires to be built from both sides. And keeping in mind that the trust is not for the benefit of either ABI or the institution, it is for arbitrations in India and for the practice of arbitration. Here, let me add one thing, that at that Saturday conference, the SG made a very scathing remark about this tendency to import stuff, from abroad and try to push it in India. I'm putting it in two parts. He's right. First part is he's right. And the clearest example I can give from our own Arbitration Act is Section 29A. Till 29A came, arbitrations were happening at their own pace. When 29 was to be inducted, everybody started shouting party autonomy, party autonomy. But when it came in and it started delivering results, then everybody said, no, now I agree, it's a good thing. It's the same thing about the coastal road in Mumbai. That was an aside. There's a lot of criticism about it, but now everybody's happy and using it freely. So the point is, we are very defensive and close to new ideas. But yes, in the Indian context, we require innovation, we require new ideas. We require to try things because India is different. Let me ask this question. How many people in the last 50 years have been convicted for perjury? Please look up the English judgments, you'll find enough. Please look up American judgments, you'll find plenty. in India, you won't find one person who's been convicted of perjury. And if you tell the court that the person has perjured, it's okay, now proceed ahead. That is how it is taken. So the point is that the thing is that the system is such, and we require to develop the system and to build trust with stakeholders. So I would say that yes, institutions must, it's not will they must work with ABI, and ABI must work with institutions. Reach out to them. And I'm sure all will respond, and it will be a great moment. Because we have forget, I'm tired of listening to this phrase all the time that we are going to develop as an international arbitration center. But in India, old times, they had this government policy of export-oriented industry. Nothing got exported. The domestic market suffered. My thing is, I believe, and at IMC, all our committee members are committed to it. Improve domestic arbitration, everything will improve. Foreigners will come in. It is like you have a jhuggi jhopdi and you want to promote tourism. Nothing happens. You got to do better in that. That's what I look at,
Right. Thank you. No, that was quite, those were interesting thoughts. Mr. Banerjee, sir, not directly in the context of Arbitration Bar of India, but according to me, very relevant to the vision of arbitration practice in India, which is fair arbitration. So, for example, again, the appointment of arbitrators under Section 11, hotly debated topic. Right now, the question is whether one party can provide a panel to another party who will then take some arbitrators or appoint an arbitrator from the panel. That is a core matter. You appeared before the Constitution bench in that matter, Supreme Court, and you said that there should not be panels. It's a very interesting argument, in fact, that if I would recommend to our viewers, if they can catch something like this online, that they should. But what do you think would promote a more fair and equitable practice of arbitration in our country? Or is there any particular aspects that you think should be changed or relooked?
Yes, there is one particular aspect which I think which actually will transform arbitration in India. And I have been looking at some of the questions that some of your panelists have been, some of your audience have been putting up. And with a view to that also, I am answering your question. According to me, what ails, see, there are enough problems in Indian arbitration, enough problems, but there are enough opportunities. But if I was to say that, supposing I had a magic wand to solve all problems of arbitration in India, I would say if you have a good set of arbitrators, you will have a good result. Simple. You have a good set of arbitrators, conscientious, honest, functioning speedily, then everything will fall into place. After all, what is arbitration? Arbitration is not your arbitrator and my arbitrator. Arbitration, good old days, theory-wise, is I and you put your belief in the same person. So Mr. Shah and Mr. Banerjee agree that we will go to Mr. Mehta. So we have full faith in Mr. Mehta. Even if Mr. Mehta makes a mistake, you live with it. And therefore, the core of arbitration is trust and basically the importance of the arbitrator. So if you can solve that problem, then I think 95% of problems fall to the ground. I don't know how. Maybe institutional arbitration may be one way of solving it, but according to me, that is the best, the most serious pain point that people have to. You see any large arbitration, if one side wins, the other side has a problem with the panel. Sometimes it's justification. If the government wins, then the private party says, oh, well, they were appointed by the government. If the private party wins, well, the government says, you know what it says. If you have a situation, forget the large contracts. If you have a situation of finance company, you know what the result is going to be. If I have to appear in an arbitration tomorrow and you come and brief me and you tell me the panel, 8 times out of 10, I can predict the result. Is that good? That's not a good solution. So maybe, somehow increase the pool of arbitrators, have other people as arbitrators, not simply retired judges, have other, training for arbitrators. That is the one thing I would be focusing on as an individual, if you ask me.
Can I add to that? I agree with Mr. Banerjee fully. Sir, the bane of arbitration today is your Section 11. At the time of Section 11, the appointment of arbitrators, believe me, it is like a marriage where bride and groom both go unhappy with the guest that has been put in their house. But nobody can say anything because of the judicial nature of the appointment. Nobody is willing to say anything. So that party autonomy, where has it gone? Why shouldn't it be there at Section 11 stage also, that in some manner a mechanism is worked out? Because neither side has an opportunity to do due diligence about the arbitrator being suggested. It is like, this Pandit is available, take him, go get married. That's not how it is. Because whether the Pandit is suited for that kind of marriage, whether parties are confident. I have seen in matters with low claims where somebody has been appointed whose fees were so much that by the fourth hearing, the claim was over. It was only the arbitrator's fees that were mounting. So these are the things that the arbitration bar and institution will have to go into and bring about a change. This is what I feel.
And
I'm sorry, these are strong views, but I'm nonetheless expressing them.
well, I think we're running out of time. So if I can just ask all of our panelists, Shikil, I'll come to you first. Is there any message that you wish to convey to arbitration practice?
First, I would want you to ask Mr. Banerjee that what would be his advice to people practicing arbitration about taking membership? That is very important, that we are getting a direct message from the president.
My advice is, this is the first time in history, internationally and nationally, that you are becoming part of a larger group who are going to promote you and your practice and professionalize arbitration. And finally, we will have a situation of Sare Jahan Se Acha arbitration Hamara. Maybe we'll reach that in 10 years, 20 years, whenever. But the Juggi Jopdi should be converted into proper accommodation. Forget about the foreigners.
Sorry, Vyom, I put that question.
No. That's so Shikil, any message you wish to convey to practitioners in arbitration?
No, I'd just like to say that personally, I'm extremely delighted to see the formation of this Arbitration Bar of India. I do believe, and I actually firmly believe that this has the potential for being a game changer for us. This will definitely bring together the best minds that we have domestically. And I would encourage all of us to join this bandwagon, hop on the ride with Mr. Banerjee as the captain of the ship.
Mr. Mehta, over to you. Any message you wish to convey to arbitration practitioners?
A very strong message. The writing is on the wall. Arbitration was there, has continued, will continue, and is here to stay. Now, whether arbitration fosters trust, growth, flourish, benefit, all that, for practitioners of arbitration, it depends on us. If we fail, is nothing new. If we fail, then let's remind ourselves of the previous 1940 Act that only brought misery and no hope or happiness and got us condemned around the world. And last, through ABI, this is a personal thing, which I strongly felt for a long time. Our esteemed and learned judiciary should always bear in mind the true letter and spirit of Section 5 of the Arbitration Act. And even in Section 11, 37, 34 matters. There requires to be uniformity, clarity, consistency in approach. While dealing with matters involving arbitration, it reminds me many times judgments that come out that if it's Monday, it must be Paris, and if it's Tuesday, it must be Belgium. And then I tell people, don't worry, by the time it's Thursday, it will be something else also. Because that is the situation. And I would really dream of a situation where there is not much reliance in arbitrations itself on judgments. Let arbitrations go the way they are supposed to go, to decide the matter, to decide the dispute on basis of good sense, common sense, not ignoring evidence, I'm saying, but on good sense, common sense, and natural justice, not on technicalities. That was not what arbitration is meant for. So that is what I would tell people. Join the damn bar and join it soon. Maybe if you join early, you'll get a discount also.
We can arrange that also.
Thank you, sir. Thank you so much. Sir, over to you.
Sir, Mr. Banerjee, the message that you would like to convey to arbitration practitioners, be them arbitrators, counsel, even maybe the clients, what do you?
I think, every crisis is an opportunity. And this is that opportunity to make a difference. I think we should be very positive about this and not highlight all our failings and see, what the solution is and be part of the solution rather than be part of the problem.
I agree.
Absolutely. In fact, thank you so much, the Arbitration Bar of India. It's a momentous step in every sense of the word. So thank you so much for agreeing to be here and helping us with this. Can we just have a look at the questions if anybody has any questions?
Can I respond in 5 minutes to the questions?
Yes.
Otherwise,
please.
it'll be a little unfair that we are in this echo chamber talking amongst ourselves. So I have actually responded to some of the questions. One question was difference amongst the classes of membership and benefits arising out of a particular class. I think really the only difference between the classes of membership is if you're a full member, you have the right to vote, etc. So that's not really a major difference. And the benefits to a particular class will be the benefits to everybody as such. And what those benefits are a work in progress, and some of which you have already heard as to what we intend to do. Then there is one question about training for arbitrators. We had a debate in the arbitration bar whether we should be training arbitrators. After all, we are only looking at counsel or advocates. But the consensus was yes, because it's part of the same package, and particularly for younger lawyers who want to be arbitrators abroad, it is quite common for younger lawyers to be arbitrators in smaller sum disputes. And there are training programs for arbitrators. There is no indigenous sort of training program only for arbitrators. There is that Chartered Institute of Arbitrators, etc., etc. There are some programs. IIAC is developing something. We are also thinking of developing something for arbitrators specifically as to how to conduct arbitrations. And then somebody says we need an institution like NCLT. Well, I have a problem with NCLT, obviously. There was some discussion as to whether we should have rather than the High Court under 34 or 37, we should have a tribunal. But and there are some views on that. But the issue there is then ultimately you can end up back in the court system, and tribunals, at least personally, one has not had a great experience of tribunals at all. And the whole purpose of arbitration is party autonomy. So, I mean, if you actually end up with a tribunal, then there is no party autonomy. Then you might as well forget about arbitration and straight away go to the court. I think those are the questions I've answered. There is one question on award enforcement. There is no procedure under the Arbitration Act. That is correct. So that, of course, moment it is treated like a decree under 36, it is executed as per the normal rules of the CPC. I mean, that's not a stricto sensu arbitration question. So that's where we are. I think I've answered all the questions I could see. And
You've answered
in
all
5
the
minutes,
questions, sir.
the Supreme Court style where everything has to be answered in 5 minutes. Come to the to keep within time.
Yes.
And,
Just ask the general.
Thank you, Mr. Staff, for it.
No, just if ask anybody if they have a question, we can take 1 or 2 questions. We have 3 minutes. So
Yes, we have 3 minutes. If there's
anybody,
anything
please
else,
put your hands up. Has
well,
anybody?
the ones who ask questions are evidently satisfied with the answers. So thank you, sir.
Okay.
All right. Thank you so much for coming. Thank
the
you.
vote of thanks.
Okay, so I'll give the vote of thanks. I'll take this opportunity. So one thing I must say that, what I was initially expecting was just a hype or enrollment seminar for the arbitration bar of India. I'm so happy to see that really what we've been talking about is enrollment to the arbitration as a bar, not as an association. And that I think I must thank the panel members, I must thank the moderator, and I must thank everybody at IMC for making that possible. As part of vote of thanks, I must of course thank the IMC committee, the arbitration committee, some of whose members are present over here, the IMC secretariat, and all the participants without whom this webinar would not have been a success or would not have happened at all. Thank you very much.
Let me just add, Bhavesh, we all must actually, all our committee members must thank Mr. Banerjee that when Vyom reached out to him, he so easily agreed.
Yes.
And there was no two thoughts, okay, whether yes or no. It was like, yes, I'm on. And that's the result today. Thank you so much from each one of us.
Yes.
Thank you, sir. Actually, you must now realize I had a hidden motive. So that's thank you so much. Thank you for this opportunity.
In the spirit of cooperation, we overlooked that.
Thank you so much.
Thank you, everybody. Thank you.